So what do if an attorney sends you 3 letters in like 5 days, um, all while getting bounce back notices that you're on vacation, of increasing franticness, ending in accusing you of um, doing drugs? And what do you do? Um, I can tell you that one of the things I did, besides write the letter that we're going to talk about today, is make a formal complaint to her supervisor. Matthew Foley, I believe, is his name. And he sent me an email back, which I think many bureaucrats could take note of. And it said, "Dear Mr. Hitchcock Cross, I have resolved this in a manner sort of like as I see fit. Thank you very much." And the "as I see fit" part may be paraphrasing there. Um, but otherwise, to the extent of, "I exercise my discretion, have a good day." Which you do get that from time to time, and I don't know, um, how that went precisely. As again, I will say that it's my belief that Andrea Olmanson continues to work on this case as previously before. The lead attorney now is Michelle Zacard again, and it seems to me that Michelle Zacard is simply signing her name to what Andrea Olmanson is writing. Again, there's these telltale signs. But we've got a lot of we're gonna, I think, read through all their briefs because I think it's worth reading. Um, so, delivered to me via from Tony Evers to uh, Joanna Stolar, the victim here. June 3rd, 2024. Attorney Benjamin Cross. By the way, it's Hitchcock Cross, 2 last names, no hyphen. Dear Attorney Cross, did she get it? Oh, she keeps doing that. It's BCHC, and that's why it's hilariously amusing, among other words, and the things that I had to suffer through. If you earn it, you might as well earn it. But it's Hitchcock Cross Examine. You see what I'm saying? All right. I regret that you did not make yourself available for a conference last week, as people do when they're sometime on vacation, although you found time to upload additional YouTube content. Fortunately, your mother did accommodate us, and we had a conversation regarding the Discover issues. I am sure that she filled you in on what we discussed and the deadlines we provided. Okay. If that's what she wants to say, that's what she wants to say. Um, the deadline. This is about as condescending as it could possibly get, but that's all right. The This is the state of Wisconsin. This is how they talk to people. The mother part, though, and let's be clear, the person that she's talking about is attorney Nola Hitchcock Cross. And the fact of the matter, I was wondering this. So what's had to happen here is that Nola Hitchcock Cross has had to get on this case and appear on telephone calls. And this is somebody who just, by the way, helped the federal government recover $70 million on a case that she had been working on for 10 years. But that's not her first one. Um, this is somebody who bills out on a rate that still astonishes me, and is, esteemed in national circles for doing high-level lawyering here. So, I'm just me. And she's had to get on to the calls because when one attorney accuses another attorney of possibly being on drugs, you're going to want a witness there. You're just going to, besides the whatever else is going on. But that's Nola Hitchcock Cross to everybody. I guess that's everybody knows that that's my mother. Let's put it like that. I'll leave that aside here, but I just there's a great line that's a quote, though, of course, from How to Win Friends and Influence People, something like that. And it says, your bad manners are only exceeded by your bad manners. Some might find that applicable here. However, to remind you, As you are aware, DOC faxed interrogatories and requests for admissions to you on March 22nd of 2004. 24. DOC has not received even one objection or response to even one interrogatory. However, you have continued to find time to create and upload YouTube content. Subsequent to DOC faxing you discovery on March 22nd, you have uploaded the following, and this does not include the shorts. Should we read them? Who told Wisconsin about Milwaukee Public Schools failures in 2021? Oh, that was Debbie Keither, by the way. TPI withholds bad news on MPS ahead of referendum, defrauding the taxpayers. Milwaukee Public Schools are still segregated. Ooh, should discriminate. I like that one. Oh, remember Poway federal complaint analysis? Wisconsin judge and DOC punish the victim. Oh. Discrimination judge rules against worker day she appears on YouTube. Telling the truth is not safe. Discrimination judge hears motion on bias. 5 judges recused themselves in the Fulleron case. Oh, we've got to get back to that. You're going to love that one. Milwaukee School Board Standard Operating Procedure. Keither versus Milwaukee. I mean, this is what you call a new service. That is what you call. These are like, no, man, these are some, thank you. On jazz cross-examination, Equal Rights Division. Keither versus Pusley et al. Complaint reading part 1. Breaking, secret recording part 4. Man, secret recording part 1. Oh, we're going back in time. Deposition, external investigations happen all be former employees. Deposition 12. What's $35 million when you have $252 million referendum on the way? Man, we are on the cusp. I will tell you what. Stick with us. And man, all right. Okay. As you are aware, statutes, administrative code, and the case law governs discovery in cases brought in the Equal Rights Division. Dude, that's awesome. That is definitely better than A equals A. Additionally, the Supreme Court rules impose certain requirements. That's also better than A equals A. You have not complied with your obligations. Okay. As I told you many times, be like Spanky and remember this line. That's just your opinion. All right. From one member of the bar to another, because what's supposed to happen is we're supposed to confer. Absolutely no question about it. But many times people don't confer when they're on vacation. Just saying. Just saying. When somebody, like, one wonders, are they watching YouTube first thing in the morning? Are they watching it all together? Do they sit around at lunch and do it? Is this like toasty time during March? Are they streaming me and commenting me like, what's happening here? When someone believes that he or she is above the rules and laws that govern everyone else's behavior, such has been demonstrated by your behavior in the discovery process, and not only Stolar, but at least one other non-DOC case that I'm aware of. Oh, I think she's showing her Wisconsin roots. Remember that we've been talking about that construction here. When a fellow does, or, okay, this is when someone engages. When a fellow doesn't do a good job, does he have a job? No, he doesn't. Right? When someone engages in significant misrepresentations, such as been made on behalf of the complainant, when somebody's a liar, what happens? When someone engages in long-standing pattern of treating others with derision and contempt, such as you have in your YouTube content, see, you thought we could make it a whole paragraph without talking about YouTube, and not this one anyway. During scheduling conference and other hearings, and when someone demonstrates an ongoing need for admiration, such as evinced by your YouTube channel, that all is suggestive of some level of psychopathy. Let me make sure I got that right. Psychopathology, I think, right? Psycho and pathology is pronounced psychopathy. Why? How the P goes? I mean, it's clearly psychopathology. You just, dang. I'm trying to get the path part on the Greek. If somebody can break that path part down. Logos, I'm on. Psycho, totally got it. By the way, absolute favorite Hermes. I'm sure you all have your favorite Hermes as your favorite, Jupiters and so forth. But my favorite Hermes was Hermes Psychopomp, and that's the Hermes in the guise of the guy who brings the dead to the land of the dead. So the psycho is the ghost, I guess, and pomp is, pomp and circumstance. Hermes Psychopomp. I mean, I'm just saying. One also then juxtaposes all that with my favorite Bertie Wooster, and you guys have no idea how often you are spared some great Bertie Wooster commentary. But if you see me acting like a turtle, for example, in any kind of interactions with people who are prattling and sort of talking down and condescending to me and the client here, and if you will hear some of my phrases, which I guess are becoming catchphrases in some extent, they are almost entirely stolen from Jeeves. For example, they have not confided in me, or I have no information. Psychopomp. I'm trying to bring that back. There is a time in which Bertie and Jeeves are jousting, for lack of a better word, and they're fighting over, basically Jeeves is getting all the credit, and all of Bertie's friends think that Jeeves is hot stuff, and they don't want to talk to Bertie. And Bertram says, among other things, that the adulation of the multitudes means very little to one. And that's the line that I think of here in response to it all suggests some level of psychopathy. And I guess to justify oneself is not really the way to go. I think the big way... you people better appreciate what I do for you. All right. Here, let's read out the threats. Let's every word by word here. This is what you look like, Wisconsin. So this is Wisconsin nice. This is Wisconsin nice. This is real Wisconsin nice. I urge you not to throw away your law license, but rather to get some insight on what is driving your conduct and to get some assistance in remediating this behavior and getting back on track. This is the part that still causes me a physical reaction here, but I'll let you interpret it yourself. YouTube might be fun, but you have responsibilities to your client, to your firm, to the legal community, and to your family. Thank you, Tony Evers. Appreciate that. Appreciate that, Tony Evers. And the attorney that works for Tony Evers that was allowed to send this to a citizen of the state of Wisconsin through yours truly is Andrea L. Olmanson, Assistant Legal Counsel, Attorney for Respondent. She's supervised again by Matthew Foley and ultimately the Secretary of the Department of Corrections, the Secretary of the Department of Administration, and of course Tony Evers, the Governor. This is from the Office of Legal Counsel, Wisconsin Department of Correction. So, we're at 14 minutes. I guess we're going to just keep it rolling. That's, oh my gosh. Do you know what it means to miss New Orleans? It's Louis Armstrong, for goodness sakes. All right, we'll be right back. All right. Well, the fam comes back, or at least portions of the fam comes back from Denmark tomorrow. And so, as much as I will confess, I'm a big believer in whole or in part here, but um, I have been not producing as many YouTube videos um, because this stuff's been rough. And I think there's just no doubt about it. And I'm glad that they're coming back, and I'm glad that we're um, hopefully going to get back into a new schedule here. But, um, it's rough. Now, let's look at the date of my. I often tell you, I frequently say that grown people who make references to Star Wars that's not my favorite. But June 30th, normally I will say Ben, let's say we have a draft here, but I say, the Department of Corrections, the state of Wisconsin strikes back. We've definitely used that theme here, but this has been striking back. I could do better than that, but hey, we'll leave it. June 30th, 2024. Dear Andrea and Michelle, this letter is in response to your many letters generally and your June 21st letter specifically. Hey, I was about to hit you with a draft here. June 30th, we're on July 11th. So this took me more than a month to respond to it. But hey, State of Wisconsin, care of Miss Andrea Olmanson, Miss Michelle Zacard, Governor Tony Evers, regarding Stoller versus Olmanson and the Wisconsin Department of Corrections. Dear Andrea and Michelle, this letter is in response to Andrea's letter to my clients of March 27th, May 21st, May 20th, May 23rd, and June 3rd, all in 2024. In those letters, you threatened my client for making public statements about issues of public interest. Although you appear to threaten me directly because I am the agent for Miss Joanna Stoller, and all the letters concerned in the litigation between Miss Stoller and the Department of Corrections, your letters and their threats are directed to my client. That was their first out, was, hey, we're not threatening your client's First Amendment rights, we're threatening your First Amendment rights. It's a little government humor that doesn't quite land over here. My client has the right to communicate her beliefs to a public audience without interference by state actors designed to deter future First Amendment activities. I guess that's if you're thinking about what you did the first weeks of July, you probably weren't as into First Amendment claims as I am. Was at that time, so that explains where the tempus fugit, you know what I mean? Tempus fugit. My client has the right to communicate her beliefs to a public audience without interference by state actors designed to deter future First Amendment activity. That statement there is designed to set up a claim. There's just that's all of those words there are elements of a First Amendment violation claim, chilling of free speech, in other words. Indeed, the federal courts are open to enforce such claims. To prevail on a First Amendment retaliation claim, a plaintiff must ultimately show that 1. She engaged in activity protected by the First Amendment. I have observed that despite your failure to find time to respond to discovery, you have found time to create and upload YouTube content pertaining to this case, including content that defames Lieutenant Miller. Your treatment of Miss Miller is regrettable. Miss Miller is a hardworking, innocent public servant. She suffered a deprivation that would likely deter First Amendment activity in the future. We'll just go over here. Let's just talk about your family here. Oh yeah, let's go. And YouTube might be fun, but you have responsibilities to your client, to your firm, to the legal community. And I'm sure I'm getting ahead of myself because I'm sure I knew and looked up all this stuff when I wrote this damn letter. but everyone likes to cite to the record. All right. She suffered a deprivation, and 3, the First Amendment activity was at least a motivating factor in the defendant's decision to take the retaliatory action. That, by the way, good case on that, Woodruff v. Mason, and quoting Massey versus Johnson. Those are like, bam. See also Bridges v. Gilbert. If you're in the Seventh Circuit, those are the cases to cite. Oh, we're getting a little prosy here. First, let us examine whether Miss Stoll, I think might be unintentionally or intentionally mirroring some of their style. First, let us examine whether Ms. Stoller engaged in an activity protected by the First Amendment. To be protected by the First Amendment, speech must focus on public concern. This is straight out of law school writing here. RAV versus State of St. Paul, Minnesota, 505. Oh, that's a Supreme Court case. All right. Oh. We've talked about that before. But that's one of those ones, that statement there is the law in the following sense. To be protected by the First Amendment, speech must focus on public concern. That's written by Stevens, not everybody's favorite justice, in a concurrence. So it's in a Supreme Court decision on the winning side, but Stevens is adding on to what the majority think. Not necessarily the strongest law, but it's quoted everywhere. So it is interesting how something that's not necessarily the law, then from Stevens getting quoted by the appeals court in the Seventh Circuit, then it becomes the law pretty darn quickly. All right. Seems like a lot more of that for another day where you're not already 21 minutes in there. Your reference letters all mention your client's activity, our client's activity, on the YouTube channel Delivered Indifference, Wisconsin. And is particularly focused on 3 public officials. That's Kevin Carr, Mac DeFesahaya, and Lieutenant Miller. You allege that Stoller defamed public officials. For example, on May 20th, you sent Stoller, there's a footnote the following. Let's see what the footnote says. Andrea's June 21st, 2024 letter states that her letters were addressed to Ben Hitchcock Cross and therefore not to Miss Stoller. And just so you know, I address other attorneys in letters that are only to other attorneys, even if they may be seen by other audiences, by their first name. That's because we are all colleagues, and I call every attorney by their first name in the state of Wisconsin when we are talking, unless we are in a public audience. And then, of course, I would address them as attorney last name. That's how I do it. You know where I got that from? Is musicians. Dude, that's exactly what all musicians are brothers as well. This position expresses, at least they used to be, this position expresses a fundamental misunderstanding of agency. Attorneys are agents of their clients. See, for example, all of these cases here. The relationship of attorney and client is one of agency. That's a quote from the appeals court. You know what that is? That's the law. Moreover, see Supreme Court rules, which, as you know, requires an attorney to keep the client reasonably informed about statuses of the matter. Why is that important? Because if you're an agent and you've got we know that the client's got to know what's going on. It's part of agency. All right. Next, let us examine whether you're... Oh, sorry. There was just a footnote there. All right, you see that you allege that Stoller defamed on the May 20th. You said Stoller the following. I have observed that you, despite your failure to find time to respond to Discovery, you have found time to create and upload YouTube content pertaining to this case, including content that defames Lieutenant Miller. Your treatment of Miss Miller is regrettable. Miss Miller is a hardworking, innocent public servant. Several of your letters referred to an Office of Lawyer Relation complaint filed by Mac DeFesahaya for comments made on YouTube about her on behalf of Warden Novak. Ms. Fesahaya, who is now employed by the state of Wisconsin, University of Milwaukee, freely admits that all of the comments concerned her public employment. Ms. Fesahaya wants the Office of Lawyer Regulation to stifle free speech. Ms. Olmson's threats follow suit. Other threats by Miss Olmanson refer to a defamation lawsuit against Dr. Keither and her attorney for comments made by Dr. Keither about Judge Calvin Furman when Judge Furman was the Deputy Superintendent for Public Schools or an administrative law judge. Therefore, your letters also reference public comments by Dr. Keither on matters of public concern, including Judge Furman's public comments and employment, which, although are not directed at Stoller, show that the letter is directed at public speech against public officials. Next, let us examine whether your letters would likely deter First Amendment activity in the future. Seventh Circuit applies an objective test, whether the alleged conduct by the defendants would likely deter a person of ordinary firmness from continuing to engage in protected activity. Oh, that's Sarita versus Hyde. It is therefore, seriously, if you have anything to do, go find some of those cases and look them up. You will be glad you did. It is therefore irrelevant if Stoller continued to post about the Department of Corrections in the face of the deprivation. What matters is whether a district court would see Miss Ullman's threat as a deprivation. This is from your May 20th letter to Stoller. I see that Attorney William F. Sultan is representing you in the defamation action brought against you by Mr. Furman that stems from other YouTube content that you have created and uploaded. Perhaps you might seek Attorney Sultan's counsel regarding your statements that malign Miss Miller. As I have previously communicated to you, I really don't want to see another attorney dig themselves any deeper than they already are. And I would think that Attorney Sutton could probably provide you with accurate and dispassionate advice. I put in some emphasis there, so I noted that. For some reason, you were compelled to send another letter the next day containing the following. The statutes and rules of our state require participation in the discovery process. They do not require the creation of YouTube content. Your law license is on the line. This is from May 23rd. From one member of the bar to the other, I am very concerned that a fellow attorney is being so cavalier with their law license. You are already facing a number of OLR complaints. Do you want to make the situation worse? ? If the problem involves substance abuse or mental health, WISLAP is there for you. As indicated above, Andrea may say that she was politely pointing out the logical consequences of ongoing contravention of the rules and laws governing the practice of law, but that is little different from the language of the mafia. Would be a shame if something bad happened to your nice law firm, or family, for example, especially when coupled with a demand to drop the suit. A district court judge may find your comments threatening, and that's what really matters. All right. Then we put a litigation hold on the department. And then we say there's still hope for an amicable solution. So, there you have it. Part 3 of the state of Wisconsin infringing on and let's be clear, all that's really happened, this poor young lady has said that she was sexually assaulted in the workplace, and instead of anybody being allowed to talk about this, we have to fight about the ability that nobody can talk about it. That's what we're talking. Instead of talking about what happened, we're spending all of our time talking about that nobody can talk about what happened in America today. So, and this is where we're at. This is what we get. This is where you and I and everybody who's watching this. So, thank you, Tony Evers. Stick with us. We'll keep you informed.